Hi, my name is Ron Zambrano. I'm partner at West Coast Employment Lawyers and also the Employment Litigation Chair. Today we're going to be talking about requesting for accommodations. Requesting accommodations requires a threshold issue of whether or not you're going to be disabled or you are disabled. Under California law, disability requires you to be unable to perform an essential life function. In layman's and man's terms, it means you can't do an important part of your job. So if you're sick because of cancer, or because you're pregnant, or because you broke your arm for some reason, for that time you need to recover, you are a disabled person. So medical leave is one of the things that most people understand is an accommodation they request for them to be not working. So what is an accommodation request that is not just a normal medical leave or time off to recover from something? So it could be something that is a daily adjustment to your work activities. For instance, if you have trouble with your hands and you need 5 minutes off every few minutes, your doctor has to provide a note. So that's a main one. Your doctor, you need to bring a doctor's note with the accommodations request and you present it to your employer, whoever the designated HR person is. If you are email savvy, use your email and CC the bosses, HR, anyone else above you so that they are put on notice that you're requesting accommodations. Now, there's a spectrum. There's things that are reasonable and there's things that are unreasonable, and there's stuff in the middle that is a case-by-case basis. So for instance, if your doctor says you need to work from your house in bed 2 days a week, 1 hour a day, that's probably not a reasonable request. And someone has called our office saying whether or not that should be accommodated. Now, there's something a very reasonable request. For instance, just needing 5 minutes off every hour to stretch for your hands because you have carpal tunnel. If there's a medical note that comes in for that, that seems like a reasonable request, as long as you are doing stretching and nothing else. So it's a case-by-case basis, but the threshold issue is your doctor has to just say what your accommodations are or requested are. They don't have to put a diagnosis. They don't have to say they need these accommodations because they have this diagnosis or this medical condition. That is not required. Your employer is not required or is not entitled to know why you need these accommodations, why you're requesting these restrictions. But they should have the right to know what those restrictions are and to have a chance to see whether or not they can be accommodated. So your employer can deny accommodating your restrictions if they can show it would be an undue hardship to do so. If you have little, smaller employer, they probably can't, they don't have a lot of people to fill in. They're not a big operation. They're gonna have a tougher time allowing long leaves of absences compared to, let's say, working at Macy's where people can be shifted around. So it's a case-by-case analysis. What you have to be careful about is if the accommodation request is outright denied, you don't necessarily have to be fired. If you can be allowed to just time off until you get better or you don't need the restrictions anymore, that is also something that an employer has to allow you to do. So remember, an accommodation request is not just, hey, can I have some time off? It's also, if you can't accommodate what my doctor's asking me, can I just have some time to recover enough so that I can come back without any restrictions and just do my job 100%? Finally, I think an important thing to notice is if you don't put things in writing, it's harder to demonstrate later that there was a failure to at least engage in the interactive process. Now that's a buzzword for us here for the employment law firm, interactive process. So what does that mean? That means you as the employee have presented notice in writing through a doctor's note of a request for restrictions to be accommodated. That requires the employer to at least try to figure out if those restrictions can be accommodated reasonably. That sometimes is a face-to-face meeting going, yeah, I got your note, this is what we can do, this is what we can't do, and you discuss it, make notes about that meeting. If that interactive process isn't done, that itself is a violation of law, regardless of the outcome, regardless if they were right or not right in failing to accommodate you. So just keep an eye on that there should be a kind of a dialogue. It doesn't have to be a long one or a very short one, but some dialogue other than just a summary yes or no. So what doctors kind of mess up on, and they do this unintentionally, is that they sometimes don't put down a date they believe the restrictions can be lifted. Your doctor may not think you will need restrictions for more than a month or for more than 2 weeks. Sometimes if they fail to put down a date that you will be reevaluated or an anticipated date that those restrictions will be lifted, the employer is within their rights to think this is a permanent restriction, which may, be to your disadvantage. So please, when you see a doctor's note, ask them, hey, can you put an anticipated date that you believe this will be either lifted or just reevaluated, so that it cannot be interpreted to be a permanent restriction. Same thing with the medical leaves. A medical note saying, hey, this person's gonna be out for a month is fine, but if they say, oh, this person needs to be out, period, that can be interpreted as an indefinite leave, and that is not reasonable under the law. So just be careful, read those notes, make sure it doesn't have a diagnosis unless you wanna share it, and there's some type of end date or a reevaluation date of what the doctor is prescribing for you. Thanks so much for watching the video, and on this topic about accommodations, please remember to like and follow us and hit the bell for more notifications.